The Committee on Ethics and Rules, to whom is referred the Senate bill to clarify the law protecting employee compensation, Senate number 1059, reports to me have be placed in yours today for the next session. Benjamin B. Dowling for the committee.
The Senator from Middlesex and Essex, Mr. Tisei.
We're going to suspend the rules first, Madam
Oh,
President.
excuse me. The Senator from Bristol and Plymouth, Mr. Pacheco, asks unanimous consent that the rules be suspended to allow the matter to be considered forthwith. Is there an objection? Chair is none. Rules are suspended. Question now comes on ordering bill to a third reading. The Senator from Middlesex and Essex, Mr. Tisei, and others have filed an amendment, which a clerk will read.
Brief recess, Madam
Okay.
President.
Okay. Senator from Middlesex and Essex, Mr. Tisei.
Thank you, Madam President. Before we get into the amendments, I know that we have a couple of amendments we're going to bring up to this bill. I was just wondering if the sponsor, either the Senator from Newton or the Senator from Lynn, or the chair of the Labor Committee, could just explain what this bill does. I remember years ago being here when we passed legislation that amended the Wage Act to allow employees to bring civil actions. I know that there was a court case that went all the way up to the highest court in the state, and the court pretty much said that chimed in as far as how the law could be interpreted, and this bill is an attempt to clearly state what the legislative intent is as far as protecting employees and dealing with wage issues. And if somebody could just explain the intricacies of it, how it works, why this is needed, what the court case was about, what the court actually said, and again why we have this bill before us today, I'd appreciate it.
From Middlesex and Norfolk, Ms. Green.
Thank you, Madam President, and through you to the Minority Leader, I do really want to thank the Chairman of the Committee for all the hard work that he put in, and the Senate President and the Chairman of Ways and Means. But the bill before us, the Wage Act, already received the unanimous support of this body in the last session, and I hope that it will receive the same unanimous support today. Senate Bill 1059 is really straightforward legislation. It clarifies that in cases where an employer has failed to pay an employee the wages they have earned and then fails to resolve the issue, and it goes all the way to court, then that employee will receive triple damages on the wages that was legitimately owed to her or him. The purpose of this bill is to protect employees and employers by clearing up any confusion about what and when triple damages will be allowed. This gives every single employee in Massachusetts an important protection. The Attorney General gets 70,000 calls a year from people who haven't received their wages and legitimately ought to. Triple damages is designed not only to prevent employers from failing to compensate their employees, it also compensates employees for the hardship that they may undergo as a result of not receiving their salaries timely and promptly, the money they spent and the lost wages, how it has affected their family. As you can imagine, especially in these economic times, many workers are living paycheck to paycheck. Any delay in getting one check can result in increased debt, additional credit card interest, penalties from mortgage companies, or other substantial hardship for these individuals and their families. I would like to point out that this bill also protects employers by helping to create a level playing field. Reputable employers suffer when they have to compete for business with companies who do not pay appropriately and who may also be avoiding unemployment insurance, workers' compensation, and other tax payments. By requiring triple damages in these cases, we are reasserting the legislation intent of previous wage acts and enforcing consequences on employers who do not follow the law regarding wage payments. So, Madam President, again, I want to thank Senator McGee and Senator Tolman for their support and for working hard on this matter. And I hope that when a vote is taken ultimately on the bill, it's taken by a call of the yeas and the nays. Thank you, Madam President.
The senator from Middlesex and Norfolk has asked that when a vote on this matter be taken by a call of the yeas and nays.
On engrossment.
On engrossment. Those joining with him will please rise.
Five. That's sufficient.
Sufficient number having risen, when a vote on this matter is taken for engrossment, to be taken by a call of the yeas and nays. The senator from Essex and Middlesex, Mr. McGee.
Thank you, Madam President, and to my good friend, the Minority Leader, I'd like to talk a little bit about the background on this legislation. You were correct. In 1993, the legislature passed legislation that would allow triple damages to be incurred for those who didn't receive their paycheck, the employees who didn't receive their paycheck or didn't receive their wages. That legislation was in play and was actually typically almost all of the cases that moved forward. Triple damages, not all of them, but many of them were awarded once they got to the lawsuit phase and were in front of a judge. That did happen. That happened from 1993 till 2005. In 2005, the SJC, on a request, ruled that the language, the May language within the legislation that had been basically accepted as the law from 1993 was not clearly being, in their interpretation, was not clearly supporting triple damages, but that it was something that was a possibility based on the language within the original legislation. And so, from that time forward, the SJC's ruling indicated that for triple damages to be in play or appropriate, there had to be evil intent or reckless disregard for another person's interests. Subsequent to that, this legislation was filed, and this legislation would again incorporate what was actually the law of Massachusetts from 1993 till 2005. It would indicate that for any incident where an employee's wages were not provided to them as appropriately required under their employment with a current employer, they would then be able to go forward, and if they did not get redress and did not get their wages, they could move forward with a lawsuit, and triple damages would be appropriate. This legislation would require the triple damages to be, or shall require triple damages to be the remedy when the lawsuit is completed. So we are now moving this piece of legislation forward. This bill was passed in the last legislative session without objection in either the House or Senate, and went to the governor's desk, and it was vetoed by the governor last year. During the hearing in this session, there was bipartisan support. Republicans and Democrats alike came forward and voiced their support for this legislation, recognizing that this legislation would incorporate practices of the state of Massachusetts that were well-intentioned and had been in play for a 12-year period up to 2005. I urge that my colleagues look favorably on this, and we again move this bill forward to the governor's desk, and hopefully in this legislative session we'll be able to make this legislation and get it signed by the governor and make it law in this legislative session. Thank you very much, Madam President.
The senator from Essex and Middlesex, Mr. Todd.
Thank you, Madam President, and through you to the members. I thank my good friend from Lynn for his explanation, which I think may have answered some of the questions which were actually raised by his predecessor speaker's presentation. So I would just ask, it seems that there's been some suggestion that there is ambiguity currently in the law. And looking at the seminal case on this, to which I believe both speakers referred to, it's a case out of the SJC in 2005, it seems to me that there is no current ambiguity, and I'd like to have explained what ambiguity it is that we're trying to resolve. Quoting from the case, In the first instance, the court stated that treble damages are punitive in nature, allowed only where authorized by statute, and appropriate where conduct is outrageous because of the defendant's evil motive or his reckless indifference to the rights of others. Later in the opinion, the court goes on to state, our conclusion comports with underlying purpose of the statute because a judge may award treble damages if they are warranted. And in this case, the court goes on to say that in a particular case, the judge in the lower court, prior to the appeal, may have overstepped his discretion. And so it seems to me that what the court has identified and indicates was occurring was in comportment with the statute, is that if there was an outrageous act or if there was a different level of knowledge in the situation, that there would be a different penalty, i.e. treble damages would apply. I don't believe that there's anything in the current law, without us doing anything else, which prevents a judge from awarding treble damages. It seems to me that the judge in each case has the discretion to decide whether or not the defendant's conduct warrants the punitive measure of treble damages, and I'm wondering what the motivation is to try to remove some of that discretion from the judiciary, which has been well defined by this case coming out of the SJC.
Middlesex, Mr. McGee.
And in response to my good friend's question, the language that's within the statute does have some language in the beginning of the section that talks about, that does have the word may and talks about a number of different things, and when it gets down to the triple damages, does not clearly, at least in the SJC's mind, identify that triple damages are appropriate. As you stated, the court did rule that it had to be an egregious, actually, I think they talked about evil intent. The reality is that, subject to the SJC's decision, there really is limited, if any, ability to recover triple damages through the SJC decision. That's not happening. In fact, the opposite is happening. Most cases are going forward, and employees are not seeing an ability to redress the need for them to get recompensated for the money that they didn't receive through the fault of the employer. The employee who is working for an employer in this Commonwealth expects to be paid. If they're not paid and they don't receive their pay, they are impacted in a very negative way. By having the language of the SJC decision to stand, it really doesn't allow employees who have really struggled to pay their bills and expect to be paid on a weekly or a biweekly basis to accept that money and then have redress so that they can move forward and force their employer to do the right thing. Again, there was no opposition to this in the last session. In fact, none of the business community was opposed to this. I served in the legislature from 1994 to 2005. I can't tell you that there was an egregious, outrageous problem within businesses where all these people were coming forward and somehow getting triple damages unfairly. This is something that had worked, and the court took a look at that language and identified that there wasn't clear language, at least in their opinion, and I don't necessarily agree with that, but that's what the SJC looked to and said that there wasn't clear language to allow triple damages unless it was evil intent or substantially egregious circumstances, which really limits 95 to 98% of any ability to go after an employer who has not paid an employee their rightful wages. So I would state that this language allows any employee to move forward, and what happens in this legislation, if an employee is not paid and they don't get their money, they can go to their employer, and if the employer pays that money, there is before a complaint is filed, they're paid their money through an honest mistake. The only damages that they would be eligible to move forward on, they could still move forward on a lawsuit. It would only be on the interest of the money. And again, it's the money they were not paid. If they're paid a certain amount of wage, but they should have been paid more wage, the only wages that would be eligible for triple damage would be the wages they were not paid. So they have an ability to go to the employer, get that money. The employer has every ability to pay that money that they didn't pay. If they don't do that, they go to the Attorney General's office. Which again, my good friend had talked about 70,000 plus per year are going before the Attorney General's office. They have 90 days to go forward on that and then move forward on a lawsuit. They have to, at the end of the whole process, the lawsuit has to be won. They have to win. So they have to move forward with facts that are going to indicate they weren't paid and that it was pay they should have received and that the court's going to rule that money should have gone to them. So I think this legislation does allow employers to recognize what their responsibility is to make sure that their employees get the wages they've earned, and it gives employees an opportunity to move forward and get the money they deserve and have a legitimate chance of being successful and moving forward and getting damages that are appropriate for the lost wages they had because of no fault of their own, but because they weren't paid by their employer.
Essex and Middlesex, I'm sorry, Mr. Tarr was up first, so I'm sorry. Senator from Norfolk and Bristol, Mr. Brown.
Madam President, I'll be brief. My concern that this is another piece of special interest legislation that's coming before us, and we're once again chipping away at the discretion of the courts to determine whether there is, a vicious or a hurtful act that, that's mean-spirited and using every other bit of language that the courts may have used to describe the actions of an employer on whether to not award treble damages, i.e. triple damages. And I have great concerns about this. It seems to be like we're going down another path where we're interfering with the business relationship. Obviously, if somebody has not paid wages, there already is a mechanism to have it be addressed. And the courts I'm an attorney, it's no secret. We have a lot of attorneys in here. I encourage you to read the decision. It's very, very clear as to what the courts look at and how they make a determination as to whether triple or treble damages should be issued. And so maybe I'm missing something. I certainly respect the gentleman that just spoke with regard to his explanation, but I have to strongly disagree. I think we're chipping away at the authority of the courts and interfering, quite frankly, with the business employer-employee relationship. If the courts feel that the actions of an employer are so outrageous, they will, in virtually every instance, issue treble damages and other penalties. And I think that we actually are making a big mistake here. Thank you, Madam President.
The Senator from Essex and Middlesex, Mr. Tarr.
Madam President, to the members, I know my good friend rose to speak, and so I'm hoping I can pose a question to him in anticipation of his future comments. It seems to me that we're dealing with a couple of different things, and I want to make sure that we're on the same wavelength. First of all, when it comes to the language of the court, my good friend references part of it, but not all of it, and so I want to make sure that we all understand that the language that the court used was that with regard to the mental state, if you will, of the defendant in these cases, it was because of the defendant's evil motive or his reckless indifference. And so we're not only talking about someone who has evil intent, we're also talking to someone who has something that's in the parlance of negligence in terms of their motivation in the case. But it seems to me that we're not necessarily clarifying something. It seems to me that we're making a policy decision, and that policy decision is that rather than a judge being able to have the discretion about whether the defendant's conduct rises to the level of being deserving of treble damages, we are now saying that in every case, treble damages will be available. And it seems to me that that's a departure from where we have been going with these kinds of statutes in the Commonwealth. And I make reference specifically to Chapter 93A, where we say that treble damages are available in cases where there is specific kinds of misconduct. So I'm wondering, are the proponents of this particular measure suggesting that there ought not to be any discretion and that treble damages should be part of the sole remedy in addition to interest on lost wages and other remedies that are already available? Are they suggesting that treble damages are now available across the board regardless of the nature of the underlying offense which led to the case?
That's the question. The Senator from Essex and Middlesex, Mr. McGee.
Thank you. In answer to my good friend from Gloucester's comments, and I think I had earlier in my earlier statements talked about reckless indifference. There are two standards that the court did talk about. One was reckless indifference, one was evil intent. And I wasn't here in 1993. The legislation that passed particularly talks about so many different remedies, including treble damages. That remedy was available and was basically in play from 1993 till 2005. That was, and again, I can't tell you how many times that remedy was resolved that way, but I can tell you I'm sure there was hundreds and hundreds and hundreds of cases resolved in that order through a 12-year period. The legislature never through that period of time came forward with a piece of legislation saying, oh, wait a minute, we didn't we didn't intend triple damages to be available to anybody who did not get their wages. We didn't intend that to be the case. What happened was in 2005, the court looked at the language and determined they felt it was vague in their opinion, and that, in their opinion, the legislation that was passed in 1993 talked about triple damages as one option. But I would say that the legislature and many of us here served in the legislature during that period of time. There was no attempt by the legislature to come back and say, wait a minute, we didn't intend the triple damages to be available to all employees who were not getting their fair wage, that was a remedy. Again, that remedy was available if the employer did not pay them their money up to the point of a complaint being filed. So if they went back to the employer and said, wait a minute, we didn't get our wages this week, and they paid the wages, there was no opportunity to move that case forward. So prior to a complaint being filed, many of those cases, I'm sure, were resolved by the employee going to the employer and saying something has happened. Again, the SJC, looking at that language and in their wisdom making a determination what that language said, felt there was vague language in there and were interpreting the legislative intent from 1993. I would again say that if the legislature felt strongly about what had happened in 1993 and that legislation was not something that was supported by either the House or Senate, there would have been a bill filed and there would have been action to make that legislation reflect, again, what the discussion is today. Again, and I reiterate this, we chaired the committee, I chaired the committee hearing this year. There was not one person that testified in opposition to this legislation. We had numerous members of both sides of both the House and Senate, from Republican and Democrat, that stood up in support of this. There was no objection to this in the last session. The business community did not come forward in a strong way last year and say that this was legislation that they were opposed to. And again, I think I can't speak for 1993, but if there was something the legislature had done, and I know that we all serve in this body, if there was something we felt had been done wrong or had somehow misinterpreted the legislative intent, there would have been other legislation filed to redress what had been done. This piece of legislation is to allow any employee who did not get their fair wages to have a certain action, and that would be to get the money back plus triple damages, because that lost money, which they may have had over a period of weeks, is a direct impact on their ability to keep their bills and their family under a house and to continue to pay their bills in a majority of situations in the Commonwealth of Mass. And what we're saying today is that is an appropriate remedy that has been a 12-year history in Massachusetts. We're not just coming forward today and saying, oh, let's now change what we had done. We're saying that what was done in 1993, this was the result of 12 years of positive action, and that we believe that we should incorporate what the legislature did in 12 years of activity to make it clear to the SJC and to the employers and employees of the Commonwealth that that's what the law is.
Essex and Middlesex, Mr. Tarr.
Thank you, Madam President. Madam President, I appreciate the gentleman's explanation, and I hope he understands that one of the reasons that we're trying to understand all the nuances of this is that in the last session this was passed during an informal session, and we didn't have the opportunity to ask these questions and have this kind of an exchange, and we're trying to flesh out all of the issues here so that we all have the benefit of understanding the action that we may well take on this matter, because we also have concerns, and I think we all should have concerns, about doing things that may negatively impact the business climate in the Commonwealth of Massachusetts when we are still down approximately 100,000 jobs from the place that we were before we get into the recession that we currently are experiencing and have not fully recovered from, even as we see another one on the horizon. And so this is a situation where we don't have the luxury of making a mistake, and so we're trying to understand the situation fully. And I appreciate the gentleman's explanation. I receive it in the spirit in which it was given. But it seems to me that in the 1993 statute, which he has mentioned and which is the subject of the litigation that I believe gave rise to this particular situation, the word may was used with reference to whether or not treble damages would be available. Treble damages in that case could be available, and what the court tells us in the SJC decision is that they would be available if there was a certain intent or mental state on the part of the defendant. It seems to me, and I would hope to be corrected if this is not accurate, that this particular piece of legislation changes that may to a shall. And that shall would make it part of the exclusive remedy rather than giving the judge the discretion as to whether or not the intent of the defendant mattered or even the knowledge of the defendant mattered. It seems to me that is a policy change that is different from both what the law said and what the court said in the case in 2005. And just for the edification of the members,
The case was Wiedemann versus the Bradford Group, and it's cited at 444 Mass 698. I'm sure the gentleman is aware of that, but I just wanted to, for the edification of the members, make that clear. And so the question is, in changing from may to shall, are we not making a major policy departure not only from where we have stood on this bill, and which the court clarified in that decision, but are we not also making a policy change from the traditional availability of treble damages, which is to create a punitive impact where a defendant has conducted a misdeed with either recklessness or some malevolent intent? It strikes me that we are making that policy change, and we need to be aware of that before we make it. So I would hope, I know the gentleman is consulting with learned counsel, and I'll speak just a moment longer to allow the fulfillment of that consultation, but I would hope that we all understand that this is more than a clarification. In my opinion, it's a policy change, and I hope that the gentleman would correct me if that's not the case, so that we can understand that we are now making treble damages the law of the land in every one of these cases, rather than something that's available subject to the discretion of the judiciary.
Ms. Green?
Madam President, I ask unanimous consent to withdraw the request for the roll call.
An objection? Chair hears none.
And the roll call is withdrawn.
And the roll call is withdrawn. The senators from Middlesex and Essex, Mr. Tisei and others have filed an amendment with the clerk will read.
By Mr. Tisei and others, an amendment relative to disclosing employment information.
Question comes
On
on adoption of the amendment, the senator from Norfolk and Bristol, Mr. Brown.
Thank you, Madam President. I will be brief. Have you ever had a situation as an employer, if you are an employer, and you've had an employee who wasn't necessarily the best type of employee, and then they go and get another job, and then a prospective employer calls you and says, "Hey, how was Johnny Jones? Is he a good employee or not?" And you know, you don't want to lie. You want them to get a job, because if they get a job, they're basically out of your hair, and they're employed again, and it's his problem. Well, this amendment is a common sense, and we have a couple of them, that basically is a disclosing employment information amendment, which protects employers, or their designee from civil liability arising from disclosure of truthful information about employees or former employees of said employer, i.e., you can tell the truth to that prospective employer and not be afraid to get sued. We're in a sue-happy time, a sue-happy state, sue-happy country, quite frankly, and if you tell the truth and you're honest and open about that prior relationship, there will be no civil liability down the road. So I think it's good for business, it's good for the parties involved, and I would certainly ask that the amendment be adopted.
Adoption of the amendment. All those in favor say aye. Opposed, no. The noes have it. The amendment is not adopted. Do we have another amendment?
Yes.
Tisei has an amendment which the clerk will read.
Mr. Tisei and others, an amendment relative to employer personnel records.
Senator from Middlesex. Question comes on adoption of the amendment. All those in favor say aye. Opposed, no. The noes have it. The amendment is not adopted. Senator Tisei has an amendment which the clerk will read.
By Mr. Tisei and others, an amendment relative to semi-monthly wages.
Senator from Middlesex, Mr. Tisei.
Madam President, this is a pretty simple amendment that would just allow employers to pay wages semi-monthly. Currently, employers in Massachusetts can pay weekly or bi-weekly, and it just gives, the amendment pretty much gives employers the ability to pay wages semi-monthly, and you know, I think this is a pretty simple amendment, and it's a question of really over-regulation, I think, on behalf of the state, that the state doesn't let employers do this right now, and this is a regulation that clearly can go, and you know, we're not talking about any different amount of money that an employee would be paid. It's just a question of the method of payment, and I think employers and employees should be able to work that out between themselves, as opposed to the state stepping in and mandating things. It does save money for employers to do it semi-monthly as opposed to bi-weekly or or weekly. So this is a very simple amendment. I do hope that it is adopted.
Comes an adoption of the amendment. All those in favor say aye. Opposed, no. The noes have it. The amendment is not adopted. Senator Tisei has an amendment which the clerk will read.
By Mr. Tisei and others, an amendment to clarify violations of the Wage Act.
Senator from Essex, Mr. Tarr.
Thank you, Madam President. Madam President, this is the remedy for the defect in the bill that we've identified in the earlier debate, and I think that the gentleman who has been the chief proponent of this bill and has done so very, very well on this floor, along with my good friend to his left, I think that they would agree that this is a meaningful clarification that avoids the kind of ambiguity that led to the situation that brought us here right now. This merely says that any kind of a violation would have to be willful in order to trigger treble damages. It's very straightforward. It draws a distinction that is settled law, not only in this field of law, but in other fields of law as well, that there has to be some nexus between the mental state, the intent of the actor, and the damages, or in this case, the penalty that's available. So I would hope that this amendment would be adopted because it does import the standard, not a standard that says that there has to be evil intent or even recklessness, but that the violation needs to be willful, implying that a willful violation is different from a clerical error or some other inadvertence that unfortunately gives rise to the unavailability of wages to a particular employee. This is a very straightforward, very simple amendment that will keep us out of the courts and make sure that the correlation between the act and the sanction is as it should be. I hope the amendment is adopted.
Comes an adoption of the amendment. All those in favor say aye. Opposed, no. The noes have it. The amendment is not adopted. Senator Tisei has an amendment which the clerk will read.
By Mr. Tisei and others, an amendment relative to undocumented workers.
Question comes on adoption of the amendment. All those in favor say aye. Opposed, no. The Senator from Essex, Mr. Tarr.
Thank you, Madam President, and through the members, drawing now your attention away from the court case that we've been discussing and not away from the subject matter, Madam President. I thought you might raise that question, being the astute observer of parliamentary practice that you are. I would point out that we are talking about the integrity of the wage system. And one of the things that contributes to the lack of integrity in the wage system is when we allow employers who work for the Commonwealth of Massachusetts to provide a compensatory reward for citizens or non-citizens who are not in this Commonwealth legally. There is no question that that's an assault on the integrity of the system. And so, Madam President, we offer this very, once again, straightforward, in the nature of the last amendment, straightforwardness, amendment that says simply that if you are going to do business with the Commonwealth of Massachusetts in any way, shape, or form, that you need to verify the immigration status of your employees. Madam President, what could be more simple than that, and what could be more central to maintaining the wage system and the fairness of our employment situation in Massachusetts than saying that employers who are transacting with us need to ensure the immigration status of their employees. And, Madam President, anticipating your next question, which is how much of a burden would this be on employers of the Commonwealth, let me suggest to you it wouldn't be much of a burden at all, because there is a system set up electronically by the federal government by which Social Security numbers can be checked for their validity. And, Madam President, that is all that this requires. Now, Madam President, I know you're going to ask another question on behalf of the business community. You would probably ask, what happens if they do that and we subsequently discover that someone is in this country illegally and ultimately getting the benefit of the taxes that are paid by the people of the Commonwealth of Massachusetts? And, Madam President, the answer to that question is that the employer who complied with the provisions of this Act would not suffer the liability for that ultimate finding because they had done that which we had asked. I know there may be one other question in your mind, and that is, how does this comply with federal preemption, given the fact that the federal government is largely responsible, if not almost exclusively responsible, for enforcing the immigration laws of the Commonwealth? And I am pleased to report that this follows the contours of the authority which is allowed to us by the federal government, in that it does not specifically enforce an immigration law. It merely provides a penalty for those who would take our tax dollars and not be able to comply with the law. So, Madam President, I hope that I've answered all of your questions as well as those of the other members, and I would hope that we would adopt this amendment so that we can say to all employers that do business with this Commonwealth that we are going to treat everyone fairly, and we are not going to advantage those that would subvert the laws of the country with regard to immigration over those who comply with the laws and may experience some additional cost or other kinds of
disadvantages as a result of that. So, Madam President, for all the points that your questions raised and for all the points that I've offered, I would hope that this amendment is adopted.
Adoption of the amendment. All those in favor say aye. Opposed, no. The noes have it. The amendment is not adopted.
Question now comes in order.
Now comes in ordering the bill to a third reading. All those in favor say aye. Opposed, no. The ayes have it. The bill is ordered to a third reading. Third reading of the bill.
An act further regulating employee compensation, Senate number 1059.
Bill has been read a third time. Question comes in passing the bill to be engrossed. All those in favor say aye. Opposed, no. The ayes have it, and the bill is passed to be engrossed. Senator from...
Report of the committee.
Report of the committee.
The Committee on